Hey, what's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. In this video, we're going to talk about the Fair Debt Collection Practices Act. I want to make this video to kind of go over the differences between an original creditor and a debt collection company because I'm getting a lot of questions here on YouTube and on TikTok where people are saying, well, I want to do a debt validation to my original creditor. And let me just clarify, and this is going to also go into details about what a debt collector has to do and what an original creditor can do, which is very different because there's certain rights that you've already signed over to the original creditor, and they don't have to perform certain actions that a debt collector has to do. So let's first go through it. This is with the CFPB. You can see up top here, CFPB Consumer Laws and Regulations. And this is an extension of the Fair Debt Collection Practices Act. And it goes into how these two got combined. So first, reading from the top, the first paragraph, the Fair Debt Collection Practices Act, Fdcpa, 15 USC 169-2, which became effective March 20th of 1978, was designed to eliminate abusive, deceptive, and unfair debt collection practices. In addition, the federal law US 15 USC 1692 protects reputable debt collectors from unfair competition and encourages consistent state action to protect consumers from abuse in debt collection. Protects reputable debt collectors. I don't know how that's read kind of weird. Um, then it says here the Dodd-Frank Act granted rulemaking authority under the Fdcpa to the Consumer Financial Protection Bureau (CFPB) and with respects to entitled entities under its jurisdiction granted authority to the CFPB to supervise for the enforcement compliance with the Fdcpa Fair Debt Collection Practices Act. So debt that is covered. The FDCPA applies to only the collections of debt incurred by a consumer, primarily for personal, family, or household purposes. It does not apply to the collection of corporate debt or to debt owed for business or agricultural purposes. All right, continuing. Debt collectors that are covered under the FDCPA, a debt collector is defined as any person who regularly collects or attempts to collect consumer debt for another person or institution or uses some name other than its own when collecting its own consumer debt. Now, I want to let you know the legal differences on a company collecting debt for itself. What they have to do, and I know this for a fact in the state of Wisconsin, a finance company or lending institution, a bank, whoever it is, even a credit card company, cannot act as a debt collector in our state. Some states may be different, but in our state, a company must either set up another entity. Now, that not to say that they can't try to call you to collect on it, but once it goes into the charge-off status in our state, when it goes into where debt collectors would be calling, then it would go into another category, and that business cannot, under the same name, collect the debt. They would have to register as a debt collection company in our state. Not to say that they couldn't use the same name or something similar, but that's something that they have to do. So the definition would include, for example, an institution that regularly collects debt for an unrelated institution. So that would be like if they're collecting for a hospital, a debt collector collected for a hospital. They're not in the same business. They're collecting medical debt, but they're not a medical provider. This includes reciprocal service arrangements where one institution solicits the help of another in collecting a defaulted debt from a consumer who has moved. Debt collectors that are not covered. Now, this is very important. Listen to this. An institution is not a debt collector under the Fdcpa when it collects another's debt in isolated instances. Again, that could be where a company purchased another company, and maybe they're collecting the debts, that was owed. Maybe a company bought out the debt and took over a company in a Chapter 11 or a bankruptcy filing. They would be able to collect the debt and not be considered a debt collector. They would just be taking over accounts. Its own debt, it originated under its own name. So that's why I'm saying it's different. But once it goes into a charge-off status, this would take it into another category. But if you owe the debt and maybe the account is still there, but they haven't officially taken it fully off the books, and they're just calling you to collect on that debt. It could be a credit card, it could be to make payments on a car, whatever it is. They're not considered a debt collector when they're doing that. So we want to be clear on that. Debt, it originated and then sold, but continues to service. For example, mortgage and student loans. So if they, let's just say a lot of the times a mortgage company, they might give it to a servicer that's going to be servicing your mortgage or your student loans, but they continue to service those payments. They are allowed to give you a call, even though I've heard when, I've heard it myself with my mortgage company. When you call and they have a servicer that is collecting, they always say this is attempted to collect a debt, even though it's not technically a debt collection for your account. It could be a debt collection for another account. So they always put that disclaimer at the beginning just in case your account falls under that category. Debts that were not in default when they were obtained. And this goes back to the original creditor having the debt, and they are allowed to make calls and collect on that debt and not have to notify someone like a debt collector would have to notify someone. And then debts that are obtained as security for a commercial credit transaction. For example, accounts receivable financing. And this goes into what I had just stated earlier, like if a business takes over another business, or which you'll hear a lot of commercials going on right now where companies can actually sell their invoices. So say, for instance, you own a company, you can act and you had about $100,000 in invoices and they haven't been paid yet. There are companies that are called factoring companies where you can sell those invoices to those companies, and they may give you $90,000 and they make $10,000 profit. So they're able to make those calls as if they're an original creditor because they're buying those receivables. So they're going into a position as if they had gave you the invoices rather than the company that provided the invoices to them originally. Now, Cfpb, consumer laws and regulations. Let's move down here. Debt incidental to a bona fide fiduciary relationship or escrow arrangements. For example, a debt held in the institution, trust, department, or mortgage loan escrow for taxes and insurance. So they're able to make those calls on there, and it would not be considered a debt collector. Debts regularly for other institutions to which it is related by common ownership or corporate control. And then debt collectors that are not covered also include officers or employees of the institution who collect debts owed to the institution in the institution's name. Legal process servicers also they don't fall under that regulation. Now, communications connected with debt collections, 15 USC 1692B and C. And if you actually go to the Fair Debt Collection Practices Act, you'll see that it's a lot more information in this. This is just a summary in a sense here. For communications with consumers or third parties with collection of a debt, the term consumer is defined to include the borrower's spouse, parent, if the borrower is a minor, guardian, executor, or administrator. When, where, and with whom communication is permitted. Communication with the consumer. Now, pay attention to this. A debt collector may not communicate with a consumer at any unusual time, generally before 8 a.m. or after 9 p.m. in the consumer's time zone. That means that they cannot call you before and they cannot call you after. Now, we know that they have violated those, and let's just say, for instance, they tried to communicate with you on Facebook or one of the social media platforms, because they have the permission to do that now, and they sent that email or that communication overnight. They would be in violation. A lot of people don't know that. Or moving on, or at any place that is inconvenient to the consumer, unless the consumer or a court competent jurisdiction has already given permission for such contacts. That's kind of what makes it vague also. A debt collector may not contact the consumer at his or her place of employment if the collector has reason to believe the employer prohibits such communication. Now, how will they know that your employer prohibits that communication? So, that's why they'll call you, and they'll call your place of employment and say, hey, we've been trying to get in touch with John. This is such and such company. We've been trying to get in touch with him. Can you either get him on the phone or make sure that he calls? So I've had that happen with an employee with another company that I owned before. If the debt collector knows the consumer has retained an attorney to handle the debt and can easily ascertain the attorney's name and address, all contact must be with that attorney unless the attorney is unresponsive or agrees to allow direct communication with the consumer. Cease communication with the consumer when a consumer refuses in writing to pay a debt or requests that the debt collector cease further communication. The collector must cease all further communication except to advise the consumer that the collection efforts is being stopped or certain specified remedies ordinarily invoked may be pursued, or if appropriate, that a specific remedy will be pursued. They cannot threaten to sue you without actually taking you to court to sue you. It is a gray area on that, but they just can't do it. I mean, I wish I could tell you what's the period of time, and but I guess the way that I would look at it is, if they said that they're going to sue you and it's been 30 days they didn't sue you, I would immediately send them a letter stating that they've made a threat and you've given them 30 days and that you want them to withdraw any collection activities. Now, you might be saying that they're going to try to take you to court after that. That doesn't matter, because what you can utilize is using this specific law stating that they only took you to court after you sent them that letter, and send that letter certified that they made the threat and it's been more than 30 days and they did not take you to court, and they only took you to court after you notified them that you want the debt to be I don't want to say forgiven, because we don't want a 1099-C, that you want them to cease all collection activities and do whatever with that debt. Don't sell it, but to just cancel out that debt. Communication with third party. The only third parties that a debt collector may contact when trying to collect a debt are the consumer attorney, a consumer reporting agency, if permissible by local law, which that's a gray area. Consumer reporting agency, that means that they're going to put that information on your credit report. The creditor, the creditor's attorney, the debt collector's attorney. That's weird. The consumer or a court competent jurisdiction may, however, given the debt collector specific permission to contact other third parties. In addition, a debt collector who is unable to locate a consumer may ask a third party for the consumer's home address telephone number and place of employment location information. This is what they do when they'll run the checks with the credit reporting agencies, and they'll do what's called a skip tracing to see your current information. The debt collector must uh, give his or her name and state that he or she is confirming or correcting location information about the consumer unless specifically as the debt collector may not name the collection firm or agency or reveal that the consumer owes any debt. So you can already see how this is like a big time gray area, because a lot of the times when they make those calls, they'll say that they're trying to find someone, and they can do this by calling references. When you give references on your application that you filled out for credit, those references could be called, and they'll just try to say that they're trying to contact you, and then that person can say, well, where are you calling from, who is this? It's going to be very difficult for that individual on the phone to say that they're not a company, and they cannot lie and say that this is a friend of theirs, because then they would be getting into where they're deceptive uh, tactics to try to get in touch with you. No third party uh, no third party may be contacted more than once unless the collector believes that the information from the first contact was wrong or incomplete, and that the third party has since received better information, or unless the third party specifically requests additional contact. Contact with a third party by postcard, letter, or telegram is allowed only if the envelope content of the communication does not indicate the nature of the collector's business. So this is another gray area. On the top left of the return address, if it has a collection agency name. Now, you may be saying, well, it doesn't say a collection agency. It just says like LVNB funding or well, if they say portfolio recovery, that's going to really throw off a red flag. But this is one of the big reasons why these companies, these debt collection companies, came up with different names that did not identify them as a debt collection company, because that was a huge problem for them. Because if they're sending you a postcard, it's already trouble, because they're revealing what they're trying to contact you with. So you won't even get a postcard. But letters they will send, but they still have to be careful. And those letters cannot be put together by third parties, because if they're doing it with a third party, they've violated what we just talked about right here. Now, moving on. Validation of debt, 15 U.S.C. 169(2)(g). The debt collector must provide the consumer with certain basic information. If that information was not in the initial communication, and if the consumer has not paid the debt 5 days after the initial communication, the following information must be sent to the consumer in written form: the amount of the debt, the name of the creditor to whom the debt is owed, notice to the consumer has 30 days to dispute any or all part of the debt. Notice that upon such written dispute, debt collector will send the consumer a verification of debt or a copy of any judgment. They always say that because they might have a debt collector coming after you for a judgment that is already in order. So now let's just break this down real quick. Uh, the the number 4 there, notice that upon such written dispute, the debt collector will send the consumer a verification of debt or a copy of any judgment. With that, something else that they did not put on here is that a debt collector cannot do anything with that debt for 90 days when you officially dispute that debt. And if you decide that you want to pay that debt, you're going to have to do something that's called a withdrawal, where you're going to have to attest to the debt. That means that you say, yes, I do owe this debt, and now they can take that out of the dispute column or the dispute process, and they can move forward with trying to resolve that actual debt. A lot of people don't know that, but that is a law, and they don't have that kind of listed here. So we got next. Notice that if Within a 30-day period, the consumer makes a written request for the name and address of the original creditor. If it is different than the current creditor, the debt collector will provide that information. If within 30 days period, the consumer disputes any written or portion of the debt or requests that the names and address of the original creditor, the collector must stop all collection efforts until he or she has mailed the consumer a copy of a judgment or verification of debt, or the names of the address of the original creditor as applicable. In practice, they'll do 90 days. They don't have it stated on here, but in practice, they will do 90 days. Prohibited practice: harassing or abusive practice, 15 USC 1692D. A debt collector in collecting a debt may not harass, oppress, or abuse any person. For example, a debt collector may not use or threaten to use violence or other criminal means to harm the physical person, reputation, or property of any person. Right here. So you got physical person, reputation, reporting on the credit report. Even though they're going to do it, they cannot use the language and say that they're going to report it on your credit so to mess up your credit. That's considered harassing. Obscene, profane, or language that abuses to uh, hearer or reader. Publish a list of consumers who refuse to pay debts except to a consumer reporting agency or to a person meeting the requirements of Section 603 F or 604(3) of the Act. Advertise a debt for sale or coerce payment. Advertise a debt for sale to coerce payment. We thinking about that. Advertise a debt for sale to coerce payment. That's I don't know about that. Publish a list who allegedly refuse to pay a debt. They do public notices, so that's what's going to be the exception, is to put it in a public notice in the publication when you do lawsuit. Annoying, abuse, or harass a person by calling repeatedly their telephone number or allowing their telephone to ring continuously. To make calls without properly identifying oneself except as allowed to obtain location information. Still very gray with that area. Still gray area. False or misleading representation, 15 USC 169(2)E. Debt collector in collecting a debt may not use any false, deceptive, misleading representation. For example, a debt collector may not falsely represent or imply that he or she vouches for, bonded by, or affiliated with the United States or any state, including the use of any badge, uniform, or similar identification. Falsely represent the character, amount, legal status of the debt, or any services rendered or compensation he or she may receive for collecting the debt. Falsely represent or imply that he or she is an attorney or that communications from an attorney. One of the things that you need to understand, this is why this is wrote in there. Attorneys will not call you for a debt. They're always going to have one of the representatives call for a debt, because once they start talking on that debt, they actually have to take over that case. That's one of the big issues that a lot of attorneys hate, is that they have to, whenever they're going to be representing something, whenever they're going to be signing off on something, they have to actually be part of it. They can't just like sign paperwork and then hand it over to someone to manage the case. They actually have to manage them. Yeah, they might have their paralegals doing paperwork and stuff like that, but they have to be actively involved. And if anything is wrong, they can end up getting in trouble, losing a law license. Threaten to take action or any action which is not legal or intended. Falsely representing or implying that non-payment of the debt will result in the arrest, imprisonment of any person, or the seizure, garnishment, attachment, or sale of any property or wages of any person, unless the action is lawful or intended by the debt collector or creditor. That means that they have to sue you. They cannot just make those threats to sue you to try to scare you into paying. Falsely represent or imply that the sale, referral, or other transfer of the debt will cause the consumer to lose a claim or defense to payment, or become subject to any practice prohibited by the Fdcpa. This is something that I talked about in a video not too long ago, where they actually said this to a individual that was on the phone. They said that, well, if you don't do something about this right now, you're going to lose your right to pay this debt. You're going to lose your right to do any defense on this debt. And that's not true. They cannot do that. Um, Next one, falsely represent or imply that the consumer committed a crime or other conduct to disgrace the consumer. Communicate or threaten to communicate false credit information or information which should be known to be false, including not identifying disputed debts as such. This is one of the violations that we see a lot with debt collectors. The problem is that the connection with the bureaus and the connection to the furnisher, which is the debt collection company who sends over the information. The gray area is that the bureaus don't always submit it. They may say that they believe that the information that was submitted by the furnisher is correct, and they won't end up forwarding that to the debt collector, and they get away with not putting that the debt is being disputed. Okay, moving forward, use or distribute written communications made to look like or falsely represented to be documents authorized, issued, or approved by any court official or agency of the United States or any state, if it was give a false impression of its source, authorization, or approval. We see documents that kind of have that look. One of the ways that I've seen this utilized is where they will submit, they will get the a lawsuit, to get the lawsuit information all set, like they're going to do a summons, and they'll send the summons without a court number, without the case number. And so they're making it look official, even though they haven't filed it. Actually, we've actually had clients where we said, "Hey, there's no case number on here. Could you please call the clerk and then ask them, has this been filed?" And we had a ton of people that said, "Hey, they called there, spoke directly to their court clerk, and it was not filed." And so this is actually giving a false impression that, that they're actually suing people. So now what we see happen after that is that they will go ahead and do the filing. And you, again, like we just talked about earlier, you can utilize their own information that they sent to you, because they're really not supposed to send you that information until they filed it. And they filed it, got a court number, and they send that to you. But they always, not always, but they get away with doing this because people see that document, they get scared, and they don't know what to do. But so if you ever get one that does not have the court case number on there, I want you to call your clerk and ask them specifically, and then use their own information against them to get that case dismissed if they try to bring it to you. Because you can use the Fair Debt Collection Practices Act, where they try to use official court documents to scare you into paying a debt. Okay, use any false representation or deceptive means to collect or attempt to collect a debt or obtain information about a consumer. Again, that's very gray. That's going to be something that you would have to argue, and then a decision would be made. But if you felt that they deceived someone or they did something to get your information, you would be able to argue that in your number one, you could send it to them, and they may make a decision not to come after you because they don't want any trouble, or you can utilize that in your affirmative defense. Okay, next, fail to disclose in the initial writing communication with the consumer and the initial oral communication if it precedes the initial written communication that the debt collector is attempting to collect the debt, and that any information obtained will be used for the purposes for that purpose. In addition, the debt collector must disclose in subsequent communications that all communications from a debt collector. So they have to say that disclaimer all the time. But something that is kind of strange, I don't know why they had it like this. A debt collector must send you the letter first. I know they have it stated right here. Maybe the person who typed this up was a little confused. I know it's coming from the Cfpb, but I'm just telling you, they're supposed to send you the letter first. Now, they might try to say, hey, we sent it and it came back, and so that's why we're calling, but they have to send you the letter first. Next, falsely represent or imply that accounts have been sold to innocent purchasers. That what they mean by that, innocent that I guess that they don't falsely represent or imply that accounts have been sold to innocent purchasers. Hold on, let's look at that. Okay, looking at the definition, innocent purchaser, that is innocent purchaser of a property who purchases for value without notice or any other party's claim against the property. So they can't try to say that it's not that they say, for instance, they know that someone else has rights to the debt. They can't claim that someone else doesn't have rights. I don't think that that would happen too many times. Falsely represent or imply that documents are legal process or that documents are legal process. No. So when they're sending you the letter in the mail trying to claim that it's a legal document, it's not. Use any name other than the true name of the debt collector's business, company, or organization. Falsely represent or imply that the documents are not legal process or do not require action by the consumer. So like they'll try to trick you and say, hey, don't worry about this. We sent it to you, and then they go and try to get a default judgment or something, like they're claiming you don't have to reply to any of it. Next, falsely represent or imply that he or she operates or is employed by a consumer reporting agency. So that goes into where they're going to put threaten to put that negative information on your credit report. So they say, hey, you don't want to pay this debt? Okay, I work for the reporting agency, and we're going to put that information on your credit report. So the next one, let's go to the next one, unfair practices, continuation. Debt collector may not use unfair, unconscionable means to collect or attempt to collect a debt. For example, debt collector may not collect any interest, fees, charges, or expenses incidental to the principal obligation unless it was authorized by an original debt agreement or otherwise permitted by law, except a check or other instrument post dated by more than 5 days unless he or she notifies the consumer in writing of any intention to deposit a check for or instrument. And I've talked about this a lot. Don't give them your checks. They will take all your checks and put them into the bank. That's why they have to have this written into the law, because they were running into problems where debt collectors were actually taking post-dated checks, and they're like, hey, this person isn't going to pay. They'll just throw them all in there. What are you going to be able to do about it? That's why they did it. So it's actually written into the law that they cannot do it. US 15 USC 169(2)(f is where that's stated. Solicit a post-dated check or other post-dated payment instruments to use as a threat or institute criminal prosecution. And then next, deposit or threaten to deposit post-dated check or other post-dated instruments before the date. We just talked about that. Cause communication charges such as those for collect telephone calls, telegrams. I guess we can add texting into there, right? To be made to any person by concealing the true purpose of the communication, take or threaten, repossess, or disable property when the creditor has no enforceable right to the property or does not intend to do so, or if under the law the property cannot be taken, repossessed, or disabled. We see that with the vehicles now, where they disable the vehicles. Use a postcard to contact the consumer about a debt. We just talked about that where it's kind of confusing because you see that we had that line right here, and then up here they had talked about the postcard. They had talked about using a postcard. I don't know where it was at on there, but they can't use a postcard talking about the debt, and then use any language or symbols or other than the debt collector's address or any envelope when communicating with a consumer. A debt collector may use its business name if such name does not indicate that it's a debt collection business. That's what we talked about. That's why they changed those names. Multiple debts, 15 USC 169(2)H. If a consumer owes several debts that are being controlled or collected by the same debt collector, payments must be applied according to the consumer's instruction. No payments may be applied to a disputed debt. Also, if when dealing with a debt collector, we've had this happen. Uh, some of the times, not all of the time, but some of the times it happens. You may have to hang up and then call them back about that other debt. That you can't have that conversation at the same time where they say, okay, now let's go over to this account, because they're going to have to go through the whole spiel about this. You're being recorded, attempt to collect a debt, and then they're just starting over. Some debt collectors may allow their representatives to do it, but most will not, because if they need to go back to the records, they're going to want to know, listen to what happened with that specific call. They don't want to open the door for any problems with the other call. So now, legal action by debt collectors, 15 USC 169(2)I. A debt collector may file a lawsuit to enforce a security interest in the real property only in the jurisdiction in which the real property is located. Other legal actions may be brought only in the jurisdiction in which the consumer lives or which the original contract created the debt was signed, and that would still be where the individual has to be in that area. Furnishing. So just to jump on this one real quick, because this is something that actually happened to me years ago, probably more than 25 years ago, is that if you have a debt collector and especially now with this internet stuff that's going on, debt collector sue, you got a loan, debt collector sues you, and then they take you to court in another state or another jurisdiction. You can actually get that dismissed, and let's just say, for instance, they take you to court and they got a default judgment, and when you get that information, you do have to do it in a specified period of time, but when you get that information, you can have that dismissed because they are not allowed to do it in the improper jurisdiction. All right, let's continue here. No one may design, compile, and or furnish any forms that create a false impression that someone other than the creditor, for example, a debt collector, is participating in the collection of a debt. Civil liability. A debt collector who fails to comply with any provision under the Fdcpa, Fair Debt Collection Practices Act, is liable for actual damages sustained as a result of that failure, punitive damages as allowed by the court in an individual action up to $1,000, or in a class action up to $1,000, and it could be even more than that. Cost of a reasonable attorney's fee in such action. In determining punitive damages, the court may consider the nature, frequency, and persistency of the violation and the extent to which they were intentional. In the class action, the court must also consider the resources of the debt collector and the number of persons adversely affected. Defense. A debt collector is not liable for violations if a preponderance of the evidence shows it was not intentional and was a result of a bona fide error that arose despite procedures reasonably designed to avoid any such error. The collector is also not liable if he or she, in good faith, relied on advisory opinion of the CFPB or on prior advisory opinions of the FTC Fair Trade Commission, even if the ruling is later amended, rescinded, or determined to be invalid for any reason. All right, so I'm not going to continue reading here. We already got, well, we already about to be finished there. I guess I will go ahead and finish. We got jurisdiction and statute of limitations actions against debt collector for violating Fair Debt Collection Practices Act may be brought in any appropriate U.S. district court and other court of competent jurisdiction. The consumer has 1 year from the date in which the violation occurred to start such action. Relation to state law, the Fdcpa preempts state law only to the extent that the state law is inconsistent with the Fdcpa. A state law that is more protective of the consumer is not considered inconsistent with the Fdcpa. Exemption from state regulations. CFPB may exempt certain classes of debt collection practices from the requirement of the Fdcpa if it has determined that the state law imposes substantial similar requirements and that there is adequate provisions for enforcement. That is a good read for you, for everyone that is still watching the video right now. I want you to drop an email saying that you were still here watching the video because I have a free gift for you. Just say, Steve said I have a free gift for watching the Fair Debt Collection Practices Act video that he put together on YouTube here. So if you need help with your credit, please visit us at thecreditrepairshop.com. Watch video What Makes Us Different so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com. We also have the FICO scores. The link is below this video. If you have debt collectors coming after you, grab my 3-pack of letters, statute of limitations letter, cease and desist collection activities letter, and the debt validation letter. And you can utilize those to stop debt collectors. If you have debt collectors trying to sue you in court, or you want us to do the response for you, there's a link below this video here where you can either get the information to do it yourself, or you can have us do it. Thank you for your time. Please subscribe to the channel. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com.